The second type of information that is generally not covered by attorney-client privilege is the location of clients. Again, there are some exceptions to this. For instance, if you have a client who has a PFA against an abuser, there is a provision under that law that allows the location of the client to be kept private and secret and not discoverable or made known to the other side. So there are some specific requirements, but generally location of clients is not protected. And also keep in mind on the criminal side of things, which is where we usually see this issue, if client is a fugitive, the attorney cannot claim privilege and not give the law enforcement the location of the client, because then they would be complicit and be violating the law themselves. Fee arrangements generally not covered by attorney-client privilege, so if appropriate, it can be released. Physical evidence. This one is the one that gets a little bit tricky when we start talking about attorney-client privilege as well as work product privilege. But the goal of privilege, attorney-client or work product, is not to hide evidence from the other side. So always keep that in mind if you are looking at a situation and trying to figure out if it's covered by privilege. So the fact that a client tells us something or gives us a document or a piece of evidence, it is not protected by privilege. It is discoverable by the other side. And obviously in the criminal law area, you have to provide the other side with any exculpatory evidence. In federal court, in civil cases, you have initial disclosures where you have to release certain information. And in state court, in civil cases, if you receive a discovery request for information that's relevant and not privileged, you have to disclose it. So you can't claim just because a client has provided you with something that it is privileged if it is in fact evidence in a case. And we're going to talk about work product privilege in just a minute and go a little more in depth into that. Another type of information that's not covered by attorney-client privilege is if a client was to tell the attorney of their intent to commit a crime or fraud. So it's usually a serious bodily injury or a serious financial injury. Or if the client was going to use legal advice the attorney gave in commission of a serious crime or a fraudulent act. The attorney does have the option, they're not required, but the attorney can notify proper law enforcement. So that is not protected. If a client says, I've already done something related to a case where the attorney is representing them, that clearly is protected by privilege, but this would be a client somehow informing the attorney that they plan on taking some future action that falls under this category. So that is not protected by privilege. Okay, so a recent update regarding attorney-client privilege. So I've included in the materials the two statutes regarding attorney-client privilege, and they're both called confidential communications to attorney. Section 5928 is civil, Section 5916 is criminal. As you can see, they're basically identical. But what I want to point out, because this became a subject of the lawsuit that's listed there in the Gillard case in 2011, that when you read those statutes, it says that counsel shall not be competent or permitted to testify to confidential communications made to him by his client, nor shall the client be compelled to disclose the same. And if you look at what that actually says, that technically it's saying that what client tells us is protected, but it doesn't specifically say that what we tell client is protected. So that became the basis of the lawsuit in the Gillard case that is sitting there. It went up through the state court system, and basically the Supreme Court held that the privilege extends to communications from the attorney to the client, as well as from the client to the attorney. So what had happened in this case is it was brought forward by a party who wanted to get information, that the other side was arguing was protected by privilege. And when it went to the trial court and the Superior Court in Pennsylvania, they found in favor of the party who wanted this information, because they said when you look at this statute, it clearly only covers communications from client to attorney, and possibly derivative communications, meaning communications back from attorney to client that includes the information that client has given them. So basically, if you repeat back some information to them, then that would be protected as well. But they found that outside of that, anything else that we happen to tell client is not protected by privilege. And so it went up to the Pennsylvania Supreme Court, and they reversed the trial court and the Superior Court. And they basically were saying what is stated in the materials, that the client input and attorney advice are often inextricably intermixed, that basically this is a two-way street regarding communications, and to try to pull out certain communications from attorney to client and argue that it's not privilege is basically unworkable. And I don't know how we would ever have that happen in practice, how we could work with that rule in practice. It just doesn't seem to make a whole lot of sense to me. A little surprised that attorneys actually brought that case, because this would affect all attorneys, not just the party they wanted to get information from in this case. But, I think generally we've always interpreted, and most people have interpreted, attorney-client privilege to protect the communications back and forth between them. And the good news is, I think it's good news, in the Gillard case, the Pennsylvania Supreme Court said, yes, it protects communications back and forth. Otherwise, every time we told a client something, we would have to throw in something that they said to us, just to make sure it was protected by confidentiality, which seems pretty unworkable. But that is kind of where we stand with that. So I think it was a good decision, but just be aware that it was a fairly recent court decision where this was decided. And so, technically I think the statutes should be rewritten or amended, but I don't know if that will ever happen. But at least we now have a court case knowing that what we tell a client is protected. Okay, so that is the end of the attorney-client privilege section. I wanted to add one more thing to disclosures and what can be released, which I think is kind of common sense, but I do like to mention it just to remind people. There can be other times where we might have to disclose information because the court has ordered us to. Now, they're not technically going to order us to release privileged information, but say you have a discovery dispute over whether or not something is actually discoverable, and one side's arguing it's privileged and the other side isn't. If the court hears that motion and decides it is not privileged, then obviously we would have to release that information. I mean, we can certainly appeal it, but if the ultimate decision is that it is not privileged, we would have to release it even if we do believe it is privileged. So there can, certainly be those types of situations where information we believe to be privileged might have to be disclosed. Okay, so moving on to work product privilege. So again, this is important, just like with attorney-client privilege, that you understand the definition of work product privilege and what information is protected. Work product privilege is also called work product doctrine, work product rule. I just stick with the privilege term. It does not matter to me, for testing purposes, if you call it work product rule, doctrine, privilege. Work product is really the key words there. So work product privilege basically covers materials developed in anticipation of litigation. So materials developed in anticipation of litigation. So that is the broad definition. And it is materials that we develop in anticipation of litigation. So what we in the law firm develop, it does not protect materials that a client develops. So if a client develops a nice spreadsheet of, information related to their case and gives it to us, it may be discoverable, because if it doesn't fall under attorney-client privilege, it would not fall under work product privilege either. So this protects what we do in the firm. Now, under the materials developed in anticipation of litigation, there are two distinct categories of information. So the first one is mental impressions. Okay. So mental impressions is, think internal. It's everything we do internally in the office. It's our ideas, our strategies, our theories, our notes about the case, our interoffice memos or the emails between you and the attorney or between attorneys. It's our legal research. So it is a lot of, what we do in developing a case that is protected. So, you create a chart or a graph or a timeline, anything like that. It is all going to be protected. And this is considered to be an unqualified privilege, meaning it is never discoverable by the other side. So it doesn't matter what happens. If it is considered to be a mental impression, it is never discoverable by the other side, and they cannot compel us to share that information with them at all. So that is the first type of material. The second type of material that's developed in anticipation of litigation is, it gets called different things: informational material, factual research, informational research. So it can be called different things, but whatever it's called, it is the same thing. It is information that we go out and collect and bring back into the firm. So think external. We go out and we get witness statements, documents, photographs, those types of things. This is protected by work product privilege. Okay, so if we get a request for that information, we're going to object. That is protected by work product privilege. However, this is considered a qualified privilege. So the mental impressions is unqualified, meaning it's never discoverable. The informational material or factual research, it is a qualified privilege, which means it may be discoverable if two criteria are met, and both of them have to be met. The first one is the party who's trying to access the information, our opposing party who's trying to get this information, has to demonstrate that the information is critical to the case. So critical, not important, not relevant, not significant, critical. So this is a pretty high burden that the party has to meet in order to be able to argue that they can discover this information. So that's the first piece, that it's critical. And the second criteria is that there is no other means of obtaining it. So, and I'm sorry, I just noticed a grammatical error in that sentence, but there are no other means of obtaining it. And so basically the original source of the information is no longer available. We can't get it from them. The other party has this information. It's critical to the case. They can argue this to the judge, and if the judge agrees, then they have access to it. So when you're dealing with that type of information, the starting point is always that it is privileged. Okay, it is protected by work product privilege. Then if it falls under this qualified privilege, the party who is seeking access to the information has the burden to show that it is critical to the case and there is no other way of obtaining that information. And if they can do that, the court could find that they can access it. So this would always come up in a motion to compel discovery. So for instance, if we get a discovery request, we argue that it is protected by work product privilege, and object to it and send it back, and the other side says we believe we meet this qualified privilege criteria. We don't agree. They file a motion to compel discovery and the judge would decide, but it is still protected by privilege, and it is up to the party seeking access to prove that it is not privileged. So that is that's an important distinction to understand, because I have seen through the years some people miss the fact that it's privilege, and because it falls under the qualified privilege, just goes to the point where it's discoverable, and it's not discoverable. It is protected by privilege, but under these very limited circumstances, a party may be able to access it.